Good morning, everybody, and welcome to our November meeting. I'd like to start with a consideration of the minutes from the public session of our meeting on September 30th. Are there any comments or questions about those minutes? If there aren't, I will entertain a motion to adopt the minutes.
Motion.
Is there a second?
Second.
All in favor of adopting the minutes from the September 30th meeting, raise your hand and say aye.
Aye.
Aye. Is there any opposed? Anybody opposed? Seeing none, the minutes from the September 30th meeting are adopted. I'll now turn to our Executive Director for a report on a number of items.
Thank you. Thank you, Chairman. Good morning, everyone. In 2014, we've been really focused on providing more outreach and education and providing more materials to those we regulate, to public officers, and to the public. I wanted to provide a brief update on some of the things that we've done since our last meeting. We've issued a new pamphlet on the post-employment guidance. Those are for state officers, employees who are leaving state service. So that's up on our website and available in hard copy outside in our lobby area. We've also issued a new ethics reminder as we approach the holiday season. It's a reminder for state officers and those who file lobbying registration of the rules pertaining to acceptable gifts. We continue to offer our comprehensive ethics training course and our online ethics orientation. We've also added, as you all know, our new online ethics training for lobbyists. Since we've launched that, we've had more than 1,700 individuals who have enrolled and who have taken the training course. And we continue to expand our training program, and we hope to offer more trainings in 2015. With respect to guidance and regulation, we've been working on clarifying the guidance on the application of the post-employment restrictions in two areas: adjudicatory proceedings, which we'll discuss later this morning, and seeking public information from one's former agency, and that we hope to take up possibly at our next meeting. We've also, since our last meeting, we held a forum with ethics officers where we've discussed the outside activity regulations, so we anticipate addressing those with the Commission in the near future also. I'm now going to turn it over to our Director of Administration, Steve Boland, to provide us with a second quarter financial report.
Thank you. For the second quarter ending September 30th, personal service was $813,194, which resulted in disbursements of 42.2% for the year. This number is a little higher than the first quarter because there's an extra payroll and payment of the performance advances to employees. For NPS, the quarter ending was $186,169, which resulted in year-to-date expenses or disbursements of 32.5%. Of that total, 73% were for release-related expenses, 8% for IT and telecom expenses, 2% for travel, and 17% for supplies and miscellaneous expenditures. So overall, the second quarter amounted to expenditures of $999,363, and on a year-to-date basis, we spent 40.2% of our cash funds.
Thank you, Steve.
You're welcome.
Thank you, Steve. Unless there are any questions about Steve's report, we can turn to the next item on the agenda, which is a discussion of a possible advisory opinion pursuant to Executive Law, Section 9416, regarding the 2-year bar in relation to adjudicatory proceedings. I'm going to ask Rob Cohen in New York to walk us through a discussion of the proposal.
Thanks. Thanks, Dan. Before I explain the substance of the opinion, I want to just provide some general background. relatively recent inquiries for guidance had prompted staff to undertake a thorough examination of the precedent, bearing generally upon the topic of a former employee engaged in litigation involving his former agency. And this examination yielded two conclusions. First, as described in the opinion, the proposed opinion, the precedent has resulted in a patchwork of rulings that are not necessarily consistent with one another. And secondly, the current role in the application of the two-year bars in certain scenarios involving adjudicatory proceedings, which can be assembled from this past precedent, is, in the opinion of staff, inconsistent with the purposes of the two-year bar. So the proposed opinion has two purposes. First and foremost, it sets out some new rules. It keeps other rules intact, but they're included in the opinion so it can be a comprehensive guide and resource. And secondly, it discusses and analyzes this past precedent in order to put the new rules in context, and explain why some changes are being made. Before I get into the substance, I want to say that staff solicited comments on this opinion from the general public. An e-blast was sent out, and it was published on our website, on the Commission's website. The Commission received a solitary comment in response to the publication on the website, and that comment mostly had to do, express the opinion that the new rules should be applied prospectively only. The opinion reflects that. We also reached out to some agencies that employ a large number of lawyers and experts and told them about the new rules. They did not express any concern with it. We reached out to the State Bar Association. The State Bar Association did not have any problem with the new rules being proposed. So that's the general background. Let me just go on briefly to the substance. The new rule is definitely not a sea change from the current state of affairs. It's more of a refinement to the regulatory regime, and I'll explain.
I'm going to have to get Aaron.
Under the current precedent, a former state employee may represent a party in an adjudicatory proceeding in which his former agency is a party, but he may not engage in any settlement talks or any discovery. That's the current state of the rule. The new proposed rule simply prohibits a former employee for 2 years after his separation from state service from representing a party in an adjudicatory proceeding to which his former agency is also a party. So as a practical matter, and this is something experienced litigators will readily appreciate, the new proposed rule should not radically alter the regulatory landscape. Simply put, under the current rule, it is highly unlikely that a client would hire a former employee subject to the two-year bar to litigate against his former agency. This is because that attorney, again, under current precedent, cannot engage in settlement talks or conduct discovery. And these are two aspects that are very fundamental to any legal representation in an adjudicatory proceeding. So while the proposed rule's impact may be limited, it certainly reconciles some inconsistencies in the staff's opinion between the current rule and the two-year bar. And again, I'll provide a brief explanation. It is clear that the two-year bar prohibits, for instance, and by just way of example only, a former, let's say, Department of Environmental Conservation, a lawyer, from writing to his agency, importuning it to apply a statute in a certain manner on behalf of his client. That's abundantly clear from the two-year bar, irrespective of any of the past precedent bearing directly on adjudicatory proceedings. But under the current regulatory regime involving adjudicatory proceedings, that same individual could take that letter, put a caption on it, pay a court fee, file it, and have a declaratory judgment lawsuit against his former agency. That would be perfectly acceptable under the current regulatory regime. And this result, from the staff's perspective, is incompatible with the two-year bar. In other words, it should make no difference whether the request for an agency to take some action is in the form of a letter or a lawsuit. Both actions are prohibited by the two-year bar. So the proposed opinion remedies this inconsistency and, in staff's view, brings clarity and coherence to the application of the two-year bar in this area. That is, in sum and substance, a brief overview.
Thank you, Rob. And we'll now open it up for discussion and questions that commissioners may have regarding this proposal.
Robert George, question for you. What is the exact language in the statute relating to the 2-year bar?
What section is it?
Relate the exact language in the 2-year bar. No person who has served as a state officer or employee shall, within a period of 2 years after the termination of such service or employment, appear or practice
Okay,
before
Rob,
such
thank
state
you.
agency.
Rob,
Wait, I'm sorry, could you just, I didn't hear the rest of it. Can you-
I'm looking for the appear or practice language.
The what?
The appear or practice language.
I was just reading it, George.
Yeah, no, you did it. You got to the point where you don't need to read the rest of it.
Oh, okay.
Okay.
Okay?
Just for security's sake, it's at 73.8.
73.8.
of the Public Officers Law.
And Rob, did you have the opportunity to go back to take a look at the Ethics Reform Act when it was enacted in 1987 into the legislative history or the bill jacket?
I did not. We did not do that for the purposes of writing this opinion.
Well, you know, I can't disagree with the logic where you're going. I do have some fundamental issues as to the legal ability for us to change the legislature's words. In February, we're supposed to provide a report to the legislature. This might be a good piece that we would want to take a look at and possibly amending. But when we start to walk through past practice and prior opinions, yes, I would say that the prior commissions diced this very finely, but they did it in the context of what the statute requires. And in terms of the actual words, appearing or practicing before a state agency does not include appearing or practicing before a court. And in terms of, and you point out some issues relating to negotiations, settlements, discovery, but if, under your example, if a former DOT employee, a lawyer, was suing the state on behalf of a client, in all likelihood, and in most instances, he or she would be dealing with the Attorney General's office, which is not his agency. So, I mean, I think this is a good idea. I'm just not sure we have the ability to do it on our own.
Well, I would just say that prior entities, predecessors to the commission, have actually said, for instance, in NYSEC, the New York State Ethics Commission, in Advisory Opinion 0001, said, as is stated in this proposed opinion, nothing in the Public Officers Law provides that a case, proceeding, or application or related proceeding may not simultaneously be before both the state agency and a court. So past predecessor agencies have, in fact, taken the view that a matter that is before a court can also be before an agency.
That is conceivable, but it's the rare instance, because generally you have to exhaust your administrative remedies prior to going to court. But it is conceivable.
And Rob, don't you see a distinction between an agency adjudicating something and a court adjudicating something? And the relationship with the individual and the prior agency that he worked for versus a court, and Judge Roth and I both know this, an independent body making a decision? Isn't it turning on who the decision maker is?
No, not for the purposes of the 2-year bar. I don't see that at all.
Why not?
I think Commissioner Cadell, your point is well taken, and I think that is what some of the decisions in our advisory opinions have tried to balance, as you said. What conduct is more before a court and what conduct is more before an agency. But a couple of things. I don't know that what we're suggesting contravenes the language in the statute. I think this commission has the ability and plenary authority to interpret the language appear in practice before such agency. And I think what Rob was saying is that you could be before a court
and before an agency at the same time.
But
It's
then- but then
appear
you're in
or
violation.
practice
Let her
before.
finish.
But then
Right,
you're in
but-
violation.
But the language is appear or practice before, and I think what we're saying is, in the real world of litigation, yes, you're actually before a court, but in the day-to-day practice of litigation, on a case, you are appearing before your former agency on a regular basis. It's basically part of the act of litigation. You're engaging in discovery, you're engaging in negotiations. Imagine the scenario that you're in court, and the judge says to the lawyers, go into a room and work this out. Well, the attorney who's a former employee cannot do that under current precedent because they can't negotiate. So they'd have to stand aside if they're part of the team and everyone else goes in. They can't even advise them because they're prohibited from doing backroom services. So I think what we're suggesting is under the current regime where the lines are leads to often absurd results and leads to a lack of clarity. And so rather than causing an attorney or a former employee to sit here in each instance and question, can I do this, can I not do that, can I do this, can I not do that, I think it's just recognizing that all parts of a litigation regularly involve appearing before your former agency. Yeah.
Just an example. I work for MTA, and my client gets run over by a bus, and I want to sue MTA. But inside my 2 years, I can't do it.
You're saying you
No,
want to represent
under the
former
current
employee.
rule, you
I want to
could do it.
represent my client. I'm the former
Under the
employee.
current rule, you could do it, but you could not engage in any settlement talks with MTA, and you couldn't request discovery from MTA.
So I'll have another lawyer do that.
That's the current rule. So
One of
I
the-
query whether a client would ever hire you if you could not engage in settlement talks or conduct discovery.
If I were
Are
the
there-
best PI lawyer in the state, I don't think there'd be a hesitation.
Ken,
But
No,
Rob,
disagree on that.
Rob, when you looked at these issues, and particularly with respect to the limitation that currently exists on a lawyer being precluded from engaging in discovery and participating in settlement discussions, did we consider whether there are disciplinary rule consequences in that instance for a lawyer to accept an engagement knowing that there's a likelihood of litigation where components of the provision of basic litigation services would be precluded by the 2-year bar? Are there ethical considerations for that lawyer? And does that inform the analysis at all?
It didn't directly inform the analysis because we don't have, obviously, jurisdiction with respect to rules that are specific to the practice of attorneys. But again, I think your question goes to the practical impact of this rule, which I think is fairly is somewhat minimized. Undoubtedly, if an attorney is unable to perform certain aspects that are part and parcel of litigation, that attorney has an ethical obligation outside of the public officer's law to inform his client of those limitations. And my guess, especially as being a litigator for 11 years prior to coming here, is that on any sort of meaningful matter, the limitations that are currently in place now under the precedents with respect to the 2-year bar would probably inhibit representation in most instances.
Right, because under Joe's scenario, if Joe's former MTA employee took on a personal injury matter and the case went to trial, even assuming that this lawyer was able to navigate their way through not being engaged in a settlement discussion, not being able to participate in discovery, taking depositions, getting the documents you need to make the case, even at a trial, if, as Monica said, the judge says to the parties, which frequently happens, guys, can't you work this out? What is the lawyer supposed to do in the middle of the trial? Gee, guys, sorry, I got a 2-year bar. I'm going to have to find somebody else for you in the middle of trial. I just wonder, are there practical implications there?
Yeah, that would be. That's why I think that the line that predecessor agencies tried to draw, I think, was in some ways too fine. was a noteworthy attempt, but on a practical level. So on a practical level, this refinement is not going to have, I think, a substantial impact. But what it does is it brings some much-needed clarity to the application of the 2-year bar in this area.
Is there a problem presently? Are lawyers coming to us and complaining about this rule, that it's not workable, I can't go to court, or we don't hear anything?
We have had some inquiries from time to time about the application of this rule in this context. Is it a problem? I don't quite know what that means, but we have received inquiries. And I also note that part of our statutory mandate is to do precisely what this opinion does, and that is to review prior precedent and make changes where the commission thinks they should be made.
But you can't change the words in the statute.
We're not doing that. I agree with you. I'm glad
I don't think we're
doesn't do that.
suggesting that, yeah, I don't think we're suggesting that we change the words in the statute. I think we are looking at the words and looking at the past interpretation and, looking at both the dissent in some of those as well as the language. And I don't think we're going beyond the language, but I think everybody's raising different policy concerns here. Just to address Commissioner Cavallo's question, I also think one of the things we also have had is agencies seeking guidance when their former employees are trying to appear in adjudicatory matters before them, whether it's in court or before another state agency, and they're questioning where the line is and how does this work, because they're troubled by the fact that their former employee is appearing before them in this context. And so, they're face to face with them and they're trying to understand.
If it's in court, it's not appearing before them.
This is not just about in court, it's also about appearing in adjudicatory proceedings that other agencies are holding.
Monica,
But-
the rules have been pretty clear prior to us for 22 years. There have been questions, and the prior ethics commissions have looked at this. When you go back, and I'm bald, I'm old, but I was in the legislature. I didn't negotiate it. I can tell you who was at the table for the most part. And if you go back to the bill jacket, you will see a large debate regarding quasi-judicial matters, because Governor Cuomo in April of 1987 vetoed the first ethics bill negotiated by the legislature and his council. And one of the big issues related to quasi-judicial matters and state officers, employees appearing in those. So the language that we're dealing with here, we're not, they knew that. Every word was, worked through with detail in 73-8. And so I'm a little troubled that all of a sudden, while you say it's not a sea change, when we're changing what I view, in my view, the language and 20-plus years of precedence, knowing that in February we're supposed to tell the legislature what we think needs changes, I would think that would be a better way to go. And I might also add that we might want to consider talking to LEC about this when we're supposed to be making this recommendation, which I believe the statute requires us to do.
It does require us to talk to LEC about some of the changes. However, this particular provision isn't about legislative employees. It's just about the executive officers.
I understand that.
So I also just note that you said that, obviously you have some insight into the legislative discussion that I don't have. However, what I do note is the city, in contrast to the New York City, in contrast to the state, actually has an express carve-out for adjudicatory proceedings, which wasn't built into this statute. And so I understand there might have been some discussions about it, but what we're suggesting doesn't contravene the language of the statute, and the precedent, the 20 years of precedent that we do have, does seem to encroach into quasi-judicial proceedings. And so it says you can't engage in settlement discussions even while it's before a judge. It says you can't engage in discovery even while it's before a judge. So you have a motion to compel, right, on discovery that you're supposed to try and negotiate before you go to a judge, and a state employee can't participate in any of that up until the point where, it's in court and you're having the argument, but it's still the quasi-judicial proceedings. So while your point is that they had a discussion about this, the 20 years of precedent does deal with quasi-judicial proceedings and sort of squiggly line in there. And so all we're trying to do is clarify the
Well,
squiggly line.
I might add that in the example Rob gave, I mean, for the most part, that former DOT lawyer/employee with the Attorney General representing the state is not going to be barred from dealing with the Attorney General's office, correct?
A former employee.
DOT employee who's suing the state, the Attorney General represents the state.
We're certainly not suggesting that a former state employee who has a legal action against the state, for example, in employment context, can't be a plaintiff.
No, I'm not saying
Yeah.
that. I'm saying, you know, just in simple litigation matters, a DOT employee, former DOT lawyer, who's suing the state, okay, say it's a DOT matter, but the Attorney General's office represents DOT.
And that, right, but the 2-year bar is not implicated there, right?
But this is part of the discussion, is the 2-year bar is not implicated, but you're basing a lot of your rationale and logic on the fact that they can't negotiate, they can't settle, but they're not talking directly to DOT, they're talking to the Attorney General's office.
I guess I'm missing your point, but yes, in your scenario, the former DOT employee can engage in settlement negotiations and can, because the 2-year bar
It's only
doesn't
for the
apply to
agency.
them.
That's right.
It's just for your former
Yeah,
agency.
to clarify, I'm sorry, I misspoke in my example. What I should have said is a former Office of Attorney General employee, not a former DEC employee. I misspoke in that example, but the point remains the same.
Well, we've had, I think, a fairly thorough and spirited discussion about these issues, and I think George and Joe and the staff have raised some issues, I've identified some issues that I think, you know, are worth additional consideration. I'm happy to entertain any further discussion about this, but I think that what we should do is have the staff take this under further advisement, and if we need to, we can discuss it further.
I mean, I don't know if this is helpful, but there are still people around who sat at that table and negotiated, and I'd be happy to give you their names.
Yeah, no, we should look into those issues.
I think that's very judicious, Chairman.
Thank you, Judge.
Just trying to emphasize the difference between.
All right. Well, unless anybody else would like to address this particular issue, I want to thank Rob for an excellent job and a cogent presentation. And we will turn to any new or other business, and otherwise, I will entertain a motion for us to enter into executive session pursuant to Executive Law, Section 94, Section 19B, to take up matters that we are required to consider in executive session, and I'll entertain that motion now. Who moved?
Judge Roth.
I did.
Okay, thank you, Judge, and Commissioner Romeo seconded. All in favor of the motion, raise your hand and say aye.
Aye.
Aye. Any opposed? Seeing none, the motion is adopted, and we will now enter into executive session. We're back in the public session. During our executive session, we considered a number of investigative matters. The commission considered and adopted the recommendation and reports of hearing officers that were made following a substantial basis hearing. If there is no other business before the commission at this time, I will entertain a motion to adjourn. So moved. Is there a second?
Second.
All in favor, raise your hand. Any opposed? Seeing none, we'll adjourn. Have a great holiday.